Hello everyone, welcome to another lecture for NCA Constitutional Law. So today in this lecture we are going to cover two important topics, criminal law. This is important, and next ancillary power. This is a very short topic but important. You might get a question on this mixed with some other question. So this will be blended. It's very rare that you get a complete case scenario only on ancillary parts. So chances are high that you will get this topic with relation to some other topic. So firstly, let's look into the syllabus. So criminal law. There is nothing doubtful here. Directly mentioned in syllabus that whenever it comes to criminal laws enactment, federal authority has the jurisdiction, section 9127. Then comes a very short but important topic. Wherever you will feel that one authority is interfering, intruding into the another authority, their ancillary power concept will come into picture. Ancillary means there is a one main area subject matter, but something supplementary or related, subsidiary. Like there is a one big, for example, there is a one big topic related to aeronautics that comes under federal authority, and then there is something related to land and something that is under provincial government. So here you can see, for example, there is a scheme, there is a law that has both these things. So you will have to see whether under the ancillary parts we can validate this particular law, whether there was actual incidental matter upon which the authority was valid in order to enact a law, or there is unnecessary intrusion, interference of one government to the another government area. So here you will see the ancillary part. So this concept means it allows each level of government to legislate on matter incidental to its enumerated parts. So something extra to their parts that are mentioned under section 91 to 95, but those incidental matters must have a proper correlation with the other government's power. So that we will look upon. Usually what happens if we feel that okay, there is nothing extraordinary intrusion, then we go for cooperative federalism. We say that okay, this is a valid legislation, there is no need to question its constitutionality, its validity. But if we feel that the few tests that we will be discussing at the end today under this topic, if those three tests are not meeting, then we have to use our analytical skill and answer and bring a conclusion that particular regulation or scheme is valid as per ancillary power or not. So talking about criminal law, we have to follow this topic based on both the authorities, federal and provincial. When we talk about straightforward enactment of law, then section 9127 comes into picture. It says federal government has exclusive one and only jurisdiction to enact criminal law, to legislate. There are two other sections that provide few parts related to crime to provinces. So those are section 9214 and 9215. Here, one thing you have to keep in mind, we are not legislating any law. Legislation enactment is the only work that has to be done by the federal government. Provinces under section 9214 can enforce the criminal law. Once you have enacted a law for the whole nation, then the particular individual provincial authority has the power, provincial government has the power to enforce that criminal law, to make their people of the particular province understand that okay, this is how we are going to follow this criminal law within their jurisdiction, within their province, including through operation of courts, police forces. So basically what we are trying to say here is whenever it comes to enforcement of criminal law that are enacted one and only by federal government, provincial government has the authority. So provincial government runs their particular provincial courts, police authorities. Then section 9215 empowered the provinces to impose fine, penalty, imprisonment for offences related to matter within their jurisdiction. So whatsoever matter is within their provincial jurisdiction, they can validly impose fine, they can validly put people into jail, whosoever is working is going against these enacted laws. So from whom we are going to get these things done? From section 90 to 14 through courts and police forces. So this is the work that has been assigned to provincial authority, but main who will make the law, criminal law? Federal government. So I hope things are clear till here. What makes Canada's legal framework unique is the division of responsibility between federal and provincial government regarding criminal law. So we can see that how beautifully the Constitution Act has divided these parts. While the federal government is tasked with creating criminal law through criminal code, enforcement is primarily the responsibility of provinces. This means that provinces are responsible for establishing police department, initiating criminal charges, trial, maintaining courthouses. Federal criminal parts are characterized by their broad and absolute nature. Broad and absolute nature means that only they are allowed to enact any criminal law. So when we get a question in examination regarding criminal division of power, criminal provision. So to fall under federal power, how a law should look like. So firstly, in order to categorize a law as a criminal law and to bring it under federal authority, these three things needs to be there. So for example, you have ABC Act of 100, for example. Now you have to decide whether this is a criminal law or not. Then further you will decide whether federal authority has power on this or not. So but firstly, in order to see whether this is of criminal nature or not, you will see the objective of the legislation, that the law must have been enacted to prohibit, to stop a specific activity. There must be penalty, as I told you earlier. Criminal law usually have prohibition plus penalty. You are stopping something illegal. If somebody goes further with that illegal act, then there is a penalty. So penalty related to breaching of that prohibition. Finally, the objective, the aim of that particular legislation must be something of criminal nature. You are stopping, prohibiting something, you are putting some penalties for an act that is of criminal nature, illegal activity. So which typically involve addressing evil, injurious, undesirable effect on the public. So something of this nature. If all these three things are there in a particular law, it means that is a criminal law, and who can legislate? Only federal government. If in examination you will see some provincial authority interfering, then you have to start analyzing that particular scenario. So now we will see 4-5 cases that will clarify things. Reference re-validity of Section 5A Dairy Industry Act 1949. This is a landmark case. Whenever in examination you are getting a question on criminal law, this case you have to mention 100%. So this is often referred to as margarine reference case. So here the three element test that I just discussed in the previous slide were established for determining validity of criminal law. So this act, Dairy Industry Act, at the very core of it, Section 5A was in question, it was the issue. So Section 5A stated that it is a federal legislation whose aim was to prohibit the manufacture, import and sale of margarine. The first two elements of the test, prohibition and penalty, were satisfied, but here, what was the main issue? Whether the third element related to criminal purpose, whether that is getting fulfilled or not. So the court concluded that this particular act, which is Dairy Industry Act, is lacking a genuine criminal purpose. The intention is mainly economic, because this is aiming at protecting the butter producer and dairy industry from competition. So whenever there is something related to competition, marketing, it is of economic nature and it has nothing to do with criminal purpose. So notably, the legislation did not address any inherent harm, undesirable effect on public peace, order, security, health, morality, despite attempts to justify its enactment under trade and commerce power. The court ultimately struck down Section 5A for its absence of valid criminal purpose. So the court said this particular section directly lacks the third element. That is why we cannot say that this is something of criminal nature. This is not a criminal law, not validly enacted by a federal authority. Next is RJR McDonald versus Canada 1995. So again, this case challenged the validity of a federal law. The aim of federal law was to restrict the advertisement and promotion of tobacco product, as well as mandatory health warning, which we see usually on the packaging that smoking is injurious to health. So despite arguments that the regulation fell under provincial power, Supreme Court of Canada upheld, said that this is a valid criminal law. Federal government has validly enacted this particular legislation, because here you can see the health comes into picture, public peace, morality, all these things come into picture. So criminal law is definitely, criminal nature is definitely getting fulfilled here. Next is Reference Re Firearm Act 2000. In response to rising concern about firearm related threats to public safety, federal government introduced an Act Firearm Act 1955 and imposed few legislation on the licensing and registration requirements for all firearms. Despite Alberta's challenge arguing that this is encroachment on provincial power, this is interference in their provincial power, Alberta said that no, we as a province have our own individual authority over regulation of firearm. Supreme Court said that no, this is something serious. Public peace is involved, safety is involved. So this is a valid criminal law power used by federal government. So court emphasized the inherent danger posed by firearm, distinguished them from ordinary property, and justified this regulation despite act regulatory aspect including complex administrative regime. Court deemed it within federal jurisdiction due to substantial public safety risk involved. So this ruling underscored the government's authority to legislate matter that threatens public safety. So again, this thing comes into picture. So you have to check all the elements that are mentioned under the third test rule. Next is an interesting case, latest one. This also you have to mention in exam definitely if you get a question on criminal law scenario. Reference Re Genetic Non-Discrimination Act 2020. Parliament's passage of the Genetic Non-Discrimination Act aimed to prohibit genetic testing, coercion, and result sharing for contractual purposes. Quebec challenged this act. Quebec said this is interference in property, provincial property, and civil right jurisdiction. Supreme Court ruled in favor of federal law constitutionality, said that the three-pronged test validly applies here. The court said that number one, this legislation's aim is to protect public interest like privacy, equality, public health. The prohibition of genetic discrimination threatened fundamental societal values, warranted. It was required that federal intervention should be there under criminal law power. So the ruling reaffirmed the government's authority to address emerging societal challenges through criminal law measure, even in areas that were traditionally within provincial jurisdiction. So if some subject matter has always been treated under provincial jurisdiction, but federal authority feels that they need to interfere, they need to legislate a matter, and that matter is under their criminal law power. Enactment of a law is valid under federal authority, section 9127, then nobody can stop, nobody can challenge Parliament's federal authority's passage of that legislation. Then provincial criminal law part that we discussed earlier in the beginning, 9214 and 15. So 9215 grants provinces the authority to impose fine, punishment within the respective jurisdiction. This provision essentially empowers provinces to regulate penalized behavior as long as they fall within the provincial head of power. However, it's important to note that provincial regulation rules must remain within their scope of jurisdiction. They cannot go beyond their constitutional authority. That would be null and void. That would be ultra wide. So there was a case, Morgan Taylor versus the Queen Nova Scotia. In this case, Nova Scotia's abortion provisions were found to be ultra wires because they were regulating an activity, this abortion thing, that fell directly under federal criminal law jurisdiction. This was not a provincial authority thing. So this particular provisions of the Abortion Act were held unconstitutional. Now we will in brief see different subject matters so that in exam if you get a question scenario related to illicit drug health, you should know that which authority has right to interfere under the criminal law part. So different subject matters, food and drug. Criminal law regulate food and drug standard ensuring public health and safety. So you have to see these particular things. The rule number 3, because prohibition you can easily see from the aim of the act, you can see penalties are there, imprisonment. Then the main thing where your analytical skills will come into picture, that will be the purpose. So you have to see what all things comes under criminal purpose. Next, illicit drugs, definitely 100% because these are related to public safety. Then tobacco, protect public safety, definitely this is a federal criminal law part. Sometimes what happens if there are two laws, one is a federal and one is a provincial, and both are not interfering with each other, both are not against each other, then there is no requirement of interference, both are valid at their own place. Like we earlier discussed Saskatchewan case, so it was related to this kind of similar thing only in examination. Most of the times you get a question related to tobacco advertisement, so you have to see that where there is a need to interfere and where there could be a cooperative federalism. So health 100%. So law intersect with health concern with authority distributed between federal and provincial government. Law addressing public health threats like Genetic Non-Discrimination Act are constitutional. Wheresoever private things comes into picture, there you can see that sometimes provincial governments can enact. Environmental protection. Criminal law supports environmental protection effort like we have R versus hydrocubic case. Then competition law. So criminal law once covered anti-competitive practices, but currently we don't cover this thing under criminal law. They go to federal authority but under the separate head, that is of trade and commerce, which we already discussed in our previous lecture. So there was a case of 1931 Pata case. Lord Atkin said that if Parliament genuinely believes that commercial activities are against public interest, they should be suppressed, they should be stopped. There is no reason why they shouldn't be made a crime. This established that the power of criminal law could extend to commerce, but many anti-competitive practices are now decriminalized. They come under trade and commerce domain. So this was the scenario of much earlier times where we always used to see that whenever some commercial activity is doing something illegal, we used to bring that under criminal power. But now in order to see these kind of things, we have separate power, separate authority of federal government, trade and commerce. Then Sunday observance law. Law regulating Sunday observance are upheld under federal provincial power depending upon their purpose. What's their purpose? For example, the Lord's Day Act. Criminal nature was crucial to its validity as without its religious purpose, the requirement for a uniform day would fall outside federal competition. So there are two cases. One is related to this Lord Day Act in case. So based on religion, religious purpose, this federal Lord's Day Act made it an offense. This act made it an offense to transact business on Sunday. So this was the act to punish divert abuses committed on Lord's Day called Sunday. So this was passed, but this particular case was held to be of criminal nature. Why? Because firstly, there is an offense. There is something related to public safety, religion. So people's interests are in question. Next, provincially, the regulation, so this is valid federal government part. The regulation of most business conduct fall under property and civil right part, allowing provinces to set limit on operating hours and close on Sunday. R versus Edward, what happened? Supreme Court of Canada ruled that provinces can designate a pause day for secular purposes, which falls within their property and civil right. Although law's purpose was secular, its effect was to restrict freedom of religion, but this secular purpose could be justified by Section 1. Therefore, here we cannot question the federal authority. So here, so again, I can just tell you the comparison so that you can get this clear in your mind, that how we have to look into the purpose in order to see whether a particular law comes under federal or provincial power. So the Law Day Act, it is a 1906 legislation. It was a federal statute, although in this case mainly the issue was related to charter, but somewhat the federal authority who enacted this law was also in question. So main argument was that the act infringed the freedom of religion granted by section 2(1) of the charter. So Supreme Court found that the act was indeed an infringement of freedom of religion, but related to division of power. So although the primary focus was on charter, there were also arguments related to division of power. So Act was a federal statute, as I told you earlier. Its imposition on Sunday observance, it intersected with the provincial power over local matter. So Supreme Court's decision did not primarily hinge on the division of power, and this hasn't been declared unconstitutional. So next, if we talk about R versus Edward 1986, here what happened? So this decision underscored the precedence of individual rights over legislative attempts to impose religious practices through federal law. So here individual rights overpowered the federal authorities enactment. So that is why this comes under property and civil right, because we are talking about individual rights of a single pause day, and this is valid provincial matter and this was valid federal matter, because something was related to a thing that affected whole public morality religion. Next is gun control. We know that any access to dangerous items for public safety falls under criminal law jurisdiction. Then whenever we are preventing any crime, 100% criminal law. Federal power allows for civil remedies in criminal law cases through courts exercising restraining, granting such remedies. Then criminal law supports regulatory schemes, even those with complex structure, as long as those schemes' purpose is to serve criminal purpose. So like we have many parts of federal and provincial government that impose penalties, with federal jurisdiction being broader in scope. So there was a case of Nova Scotia Board of Censor versus McNeil. Supreme Court of Canada here determined that censorship of film did not constitute criminal offense, because court said that this comes under property and civil rights. This is related to regulation of a particular industry. So we are bringing this into property and civil right nature. Next topic, ancillary parts. As I told you earlier, what do we mean by ancillary parts? Something subsidiary, something supplementary. So ancillary parts refer to authority of one level of government to encroach upon the jurisdiction of another level of government in order to implement a comprehensive regulatory scheme. This doctrine allows cooperative federalism. It means, for example, whenever there is a matter that is related to federal as well as provincial both, then courts apply this power rule and see whether both can work in coordination, cooperation, or whether one is unnecessarily interfering to the other authority's power. So it refers to authority of one level of government, for example federal, to encroach upon the jurisdiction of another, for example provincial, in order to implement, whenever any authority has to implement some kind of scheme, regulatory scheme. This doctrine allows for coordination and cooperation between federal and provincial authority to address complex issues. Courts will see to what extent both can work together in coordination. In Quebec versus Lacombe, Supreme Court used the ancillary power doctrine to assess whether a provincial law exceeded its jurisdiction. So whenever the courts have to solve this kind of question, that if some authority has exceeded their jurisdiction while regulating, while implementing any scheme or any regulation, then they use this power. So in General Motor versus City National Leasing case, the court applied this doctrine to determine validity of federal law that encroached upon provincial jurisdiction. So here in this case, federal law interfered into provincial jurisdiction, but Supreme Court expanded upon the notion that a measure may be considered valid even if it falls outside the jurisdiction, provided it is an integral part of the scheme falling under the jurisdiction of that government. Supreme Court applied this doctrine in this case to ascertain whether federal law exceeded its jurisdiction. So three-step test is employed whenever Supreme Court or any other court has to see that ancillary doctrine is applicable to federal law and whether federal law is interfering, encroaching upon provincial jurisdiction. So how we will come to the conclusion. So for first thing, we will see extent, level of interference. Then the court acknowledged intrusion but deemed it limited. So this all things happened in the last case that we discussed. Secondly, the validity of act itself is examined. With a special focus on trade and commerce power involving five-part test, the court found the act to embody a comprehensive scheme aimed to curbing activities that hinder competition. So we will see what is the purpose of the act, whether the act itself is valid. Then lastly, the court evaluated whether the impugned provision is adequately integrated into valid legislation. Then we will see, the court will see whether the provision that is in question upon which some authority has encroached, used their extraordinary, unnecessary jurisdiction is properly integrated into the valid legislation. So it was held in this case that the act, this particular legislation, need not solely apply to interprovincial trade like related to only one. It was something, competition was something related to whole nation. It was a matter of national interest. So it also applies to intra-provincial trade. So as a result, this federal legislation cannot effectively regulate competition if it is only related to one particular province. So federal legislation can only regulate a matter. We will say that federal legislation can only use its valid powers if it is related to something which includes national interest more than one province. If it is something related to only interprovincial trade, then there is no need of federal legislation. Then provincial government has the authority, has the power. So let's apply this ancillary power rule in one more case. Quebec Attorney General versus Lacombe that we discussed earlier. Here we are providing the details. There was an issue of clash between provincial zoning law and federal jurisdiction over aeronautic. So Lacombe was a director of an air excursion business, wanted to build airdromes on a lake. The local municipality contained a conjunction against the construction pursuant to provincial zoning law. He argued this pursuant, saying that the provincial zoning law were ultra vires to the province. So court looked at, did the provincial law of related to this zoning construction cause an intrusion? So answer was yes. Were the provincial laws valid? So court went through pith and substance analysis here, determined the provincial purpose was laying use of planning which was valid provincial subject matter. So here the provincial law was 100% valid. So third question, is the impugned provision sufficiently integrated into provincial scheme? So provision was not sufficiently integrated. It lacked the integration clear-cut scenario, was supported by lack of correlation. So the areas for which this provincial law has been enacted, there wasn't a proper relation between that enactment of regulation. So the areas affected by zoning restriction and the ban on the airdromes, there was no proper correlation. So provincial authority lacked jurisdiction here. So by this, in exactly same manner, in examination you will have to bring up these three issues in such scenario. If you're getting a question related to clash of powers, ancillary powers, then you have to see all these things one by one. So here you can see, like, in order to see whether a particular law is valid, the court applied pith and substance analysis. So whatever topics we are discussing, it does not mean that you will in examination have to apply only one particular topic in one question. Most of the time, one IRAC, one question, one proposition requires the application of at least 2 to 3 topics. So once you will be done with whole syllabus, then you will get to know how you're going to apply more than one topic in one case scenario. So this will require practice also. So here we are ending our two topics, criminal law and ancillary powers. Criminal law was clear cut. Federal jurisdiction we know, then under 9127, then 9214 and 15, provincial jurisdiction. Nothing confusing there. With regard to ancillary powers, we have to see three questions. So these are the three questions, these are the three tests. So wherever you are feeling that one authority is interfering into another authority, there is a legislation, there is a law, that is, there is a scheme that is having areas which comes under federal and provincial both. You will see whether that interference is unnecessary, whether that particular law is valid or not, and thirdly, you will see whether the provision that is in question is sufficiently integrated, or the areas that have been implemented, that have been enacted, like there's a federal authority, there's a federal legislation, and the subject matters that they have included in their particular law are from provincial authority. So you will have to see whether there is a particular connection, relation, or like in this question, there was no correlation between the areas that were affected by the zoning restriction and ban on air drums. So there was no necessity of this kind of legislation here. So you will answer all these three questions, then your ancillary part topic will be completed. So that's all. Thank you and good luck.